Hi, I'm Hannah Denton-Jones, and this is a supplementary video for week 2 of Knowledge November. We talked in the other video this week about constructive dismissal and accepting a breach and losing the right to claim, for example, constructive unfair dismissal. And I use the example of employees waiting a year to make a complaint. So it's always going to come down to the devil being in the details of these things. So perhaps if we distinguish between changes with sort of immediacy in terms of practical impact and changes that may have some time before there's a practical impact. So using the example of something immediate, we cut somebody's hours or change their role or we change their pay, that's an immediate change. If the employee continues in work after we've made that change and they're now being paid less or working the new pattern or doing the new role as the role has now been defined, the longer that goes on, the harder it will become for the employee to object. So I'll give you another example from the case law. There was a case of somebody who had a reduction in the amount of mileage that they were going to be paid for business travel, didn't raise it for 6 months. There, the tribunal found it wasn't clear enough that he was objecting at the time. And he had sort of implicitly accepted it as the time had gone by. So from an employee perspective, very important to shout if something's a problem. Contrast that with a change that maybe takes a lot longer to kick in. So certainly anything to do with pensions perhaps is often a long way off in anybody's mind, or maybe something to do with sick pay when the person isn't currently sick or thinking about it, or parental rights when the employee is currently sort of young, free and single. They're not going to be thinking about those things. Anything that's kind of further ahead in the distance, then it will become easier to be able to persuade a tribunal that it wasn't necessary to object right at the time that it was introduced. There've certainly been cases around mobility, for example, changing where you work from, where tweaking that in the contract wasn't a sort of for today matter. It was something that might apply in the future. So there's more scope, if you like, for employees to bring complaints about the things that are perhaps further in the distance than the things that are sort of today things. I hope that makes sense. Please do email me if you've got any questions, adenton@refreshinglawltd.co.uk. Thanks.